number 3, Hetelekides versus County of Ontario.
Please, the court. Mary Jo Corona from Adams LeClaire on behalf of the appellant. I'm here today to argue for reversal of the Fourth Department's opinion and to base that reversal on the Goldman case, which was correctly decided on the basis of principles that have been in place for a long time.
So,
Principles
counsel,
about
let me ask you, what's your position as to what the county, the treasurer, should have done once they realize that James has passed, once they realize that he's deceased? What should they have done?
halted the proceeding with respect to this particular taxpayer and sought application, or made an application to either the Supreme Court or the surrogate for guidance and instruction on the way in which an appropriate person could be appointed to accept the service under 1125. That did not happen here. And it's clear that our client
Why
never...
can't they rely on the fact that there should be someone who's responsible for the estate that should inform them of where any correspondence should go?
The
And
law on
inform
that-
them that the person's deceased. I mean, they didn't even learn it from plaintiff, correct?
They learned it independent of plaintiff. And they
Correct.
knew in December, well
Correct.
before the redemption period, that the taxpayer had passed
Yes,
away.
and the plaintiff
what
is
if-
the administrator, right, the executor of the estate, listed in the will, is the wife of the decedent.
Was a known and acknowledged interested party and could have been appointed by the surrogate to accept the service under 1125. But the respondents don't do that here.
How long did she wait to get those letters testamentary?
June of the next year.
A year, and so doesn't that seem a bit unreasonable to have the county in this position, because this problem would have been resolved if the executor would have moved?
It would have been as easy as making the application for the default judgment, which they made in February of '07.
But couldn't you have filed a declaration of interest before that was done a month after, or at least 3 weeks after you clearly knew, your client clearly knew about the proceeding, and no motion under 1126 is made, nothing's done to try to stop the foreclosure proceeding at that point, when you had actual knowledge?
Well, she was entitled to notice, and she didn't receive that notice.
But you had
And the-
actual knowledge at that point.
And the burden is on the municipality that's foreclosing, not on the taxpayer or even an interested party.
The burden
under
of providing notice, is that?
The burden was on the municipality under 1015
So
to
let's say
to
they
make
complied with the
applications so that,
statute. They
pardon me?
comply with the statute, and they've given notice as required under the statute. So why in this case, let's assume that, I know you dispute that, but let's assume that, why in this case then do they have to do anything else? She obviously got notice before
Well,
the
with all
foreclosure.
due respect, it's not disputed, because it's been acknowledged that the notice could not have been accepted or signed off on by a dead person.
Right, but they filed the notice according to the statute, right? They followed the procedure in the statute. Let's assume that's true.
At the beginning, when the process was commenced, that's correct. But Goldman says that you can't maintain a tax proceeding against a dead person.
Well, can you-
And that
can you-
if it occurs, if you've commenced it,
So was it against him personally, or was it against the property?
so the issue there is whether this is strictly in rem. And that goes to the dissent's view in Goldman. And clearly that dissent is wrong, because it's based on the notion that there's a fiction and that you don't have to have the same notice provided in the case of an in rem proceeding as opposed to in personam. And the issue there is, well, there wouldn't be a need for that direct actual notice under 1125, because that person wouldn't have any interest that would be compromised by the conduct of a sale without proper notice under 1125. And that's not true here, because the appellant was going to stand to lose her property interest in the Acropolis restaurant And she was also going to forfeit all the equity. So that there is a vast difference between what happens under a tax foreclosure sale, whether it's in rem or not.
What was the
As-
appellant's property interest in the Acropolis restaurant at the time that she was served with the notices, or at the time that the notices were served?
She was due to inherit his interest under the will.
But she had not yet perfected that
That's correct. The will
inheritance.
had not been processed. And that's why 1015 is so important, and why there was a burden on the municipality to ask the court for guidance, particularly in the case where the
Let me ask you
municipality
this,
was...
what if, let's say we agree with you that there had to be more than what they did here, but let's say we don't agree with what you've already suggested is what they should have done. Could they have posted it on the door, informing anyone who would have an interest? Is it not reasonable to assume that someone who has an interest in this property, knowing that James is now deceased, would visit or would have some interest in seeing if anything's been put on the property, receiving the mail?
So respondents are taking advantage of the process in Article 11. And the only way you can get actual notice under that process is 1125. And that was not provided to our client. And it could have easily been provided to the client. It could have easily been provided well before the treasurer's visit on the day before the expiration of the redemption date.
And is that because the municipality knew that James was deceased at that point?
Thank you, Your Honor, because that is perhaps the key issue in the case. What was the extent of the municipality's actual knowledge about the taxpayer's status and the existence of an interested party?
Did they know he was deceased when they mailed the 1125 notices out?
Well, all that they did when they mailed out the
No,
notices
but answer
is
my
what's called
question.
for
Did
by
they
the...
know? Did they know he was deceased when they mailed the 1125 notice?
I don't know if they did, but they knew well before the redemption period expired in December. And they were so concerned about it that they put that name down on a list with a bunch of other property owners and identified the need to do something.
So this isn't really an 1125 compliance issue. This goes more to the adjunct due process consideration. They should have done more than what was done here because at some point they became aware that James had died.
They were
Is
aware
that it?
not only of the death of the taxpayer and that the taxpayer could not have signed for the receipt of the notice.
Somebody did, though. Somebody signed for it, right?
A waitress signed for it.
Somebody at the restaurant.
Yeah.
Yeah.
Not a
What if
property owner.
what if they didn't know that Demetrius had passed away?
That's a different case. That is a different case.
And so now that they know, or we're assuming they know, what's the rule that you're looking for? What's a municipality to do?
Well, the rule is established by both the Goldman principle that you can't sue a dead person, you have to halt the proceeding.
Well, that doesn't seem to turn on knowledge at all, right? If the person's dead, it doesn't matter whom you know, if that's how you
I think it
articulate
does-
the
I think
Goldman rule.
It does turn on knowledge when you're talking about whether or not you have a jurisdictional defect due to the fact there
Well,
wasn't
is the-
notice on a dead
Is the
person.
rule that you can't sue a dead person, or you can't sue somebody you know to be dead?
The rule is you can't sue a dead person.
So it doesn't matter what you
You
know.
can proceed with that, and then you expose yourself, you expose your proceeding and what's occurred in that proceeding to it being nullified later on down the pike. That's what happens.
Counsel, as a matter of practicality, I could conceivably see that rule applying in Hopewell, but if you go to a place like Brooklyn, New York, if the requirement is that the tax collector has to go to the surrogate's court to have a representative appointed in order to collect the taxes, you're going to create a massive strain on the tax collector and the surrogate simultaneously.
And the distinguishing factor here is that there was knowledge that the taxpayer was deceased, and there was knowledge about an interested party.
So it is what Judge Singa says. It's just when the tax collector knows that the party is deceased, not when the party, not your answer to Judge Rivera's question, which was any time the taxpayer is deceased. Which is it? I'm not clear.
The proceeding is subject to nullification if you've sued a dead person. If you go ahead and proceed and you get a judgment and you had no knowledge about the fact that the taxpayer was deceased and you had no knowledge about a potential interested party, then your proceeding goes on, but it is subject to nullification later on. If someone comes forward and says, oh, there's a jurisdictional defect and it was due to a failure to provide notice. But that's not the case here. And it was very simply resolved by going to the Supreme Court or going to the surrogate and saying, we have commenced this proceeding, we know the taxpayers passed away, we know where the interested party is, we know who the interested party is.
Let me go there. Why do they know she's the interested party?
Well, the testimony is that they knew she was that Mrs. Hetelekides was the widow of the taxpayer. And they also testified that they thought she was
There's a presumption
working.
that the widow is going to take at least some partial interest, if not full interest in the property. Is that why?
I think it was
It's
acknowledged
that
in the
marital connection to the decedent?
correct. And also they formed that belief.
So when the treasurer goes in person to the restaurant, and she has testified, right? I mean, the understanding is that she works there. She's there all the time, correct?
I don't think the testimony was that she was there all the
He's
time.
made calls and he goes in person.
Without a
And there's never a response.
without a 1125 notice in his
No,
hand.
I get that point. We can discuss that in a moment, even though the light is red, if we can just finish off this line right here. They've gone in person, made several calls, said, please return these calls, it's really important. And she doesn't.
I don't think he ever asked for her. I don't think he ever asked for anybody by the last name of
Asked
Hetelekides.
for the manager or owner.
He asked for a manager or owner during the visit on the day before the expiration of the redemption period. That's correct.
Let me ask you this. The tax records, I believe, also show an ownership interest by a company called GeoTass, Inc.
Correct. That was showed up in the abstract, and I believe that the respondents testified at trial that they included GeoTass in the noticing because they weren't sure what that was.
They served GeoTass, Inc.
They mailed to
Right.
yes.
As
to
required by the
GeoTass.
statute,
That's
yes.
correct.
And
I know of
GeoTass
my client doesn't have any interest in GeoTass. She testified she didn't even know what it was. So there was some confusion on the part of the municipality as to who the owner of the property was, I
Did
guess.
GeoTass own a portion of the property?
No. It was owned outright by the taxpayer.
Thank you, counsel.
Good afternoon, Your Honors. May it please the Court, Jason DePonzio appearing on behalf of the county respondents. The Fourth
Who
Department.
was entitled to notice here?
Your Honor, the parties entitled to notice is determined as of the date of the filing of the list of delinquent taxes, which happened in November of 2005. At that point in time, James Hetelekides was still alive. The county then contracts with an abstracting company to search the public record to determine that universe of interested parties. And under this set of facts, we had James Hetelekides and also GeoTass, Inc., who were the parties entitled to notice under RPTL 1125 is showing up in the public record. Then we fast forward to October of 2005. We have 3 separate certified mailings of these statutory foreclosure notices being sent, plus 3 regular first-class mailings of those same notices being sent to the restaurant being operated at the property. The certified mail cards come back signed, and the regular first-class mailings are not returned at all. So there was no indication to the county that there was any infirmity with the address that was used.
So you're saying the statutory process was completely fulfilled without incident?
Completely fulfilled without incident.
And then where in the sequence of events do you learn that Mr. Hetelekides had passed away?
Your Honor, according to the testimony of the treasurer, in late December, the county will typically go and review properties that have been unredeemed. So in this instance, the treasurer's testimony was maybe the property contains an operating business, or maybe there's a property that has no mortgage, or it's a property that involves an elderly person. Then they will review it for additional outreach. And it was during that meeting that it was learned that Mr. Hetelekides had died, according to the testimony. So this meeting, the redemption deadline was January 12th. So this was only a couple of weeks before the redemption deadline.
So
would
upon
expire.
finding that out, do you have any enhanced responsibilities?
Your Honor, there are 2 concepts to address your questions. And the Second Department respectfully conflated those 2 concepts, and they are jurisdictional as well as due process. Jurisdictionally, no. The Fourth Department got it right, that the county was not required to petition surrogate's court to have a personal representative of the estate appointed in order to receive service of these notices. Because in order to require that, we're confusing in personam jurisdiction with in rem jurisdiction. In rem jurisdiction is brought against the property. In personam is seeking personal liability against individuals.
What about due process?
And then due process, the Fourth Department went on to analyze, assuming arguendo, that upon gathering this information, something more was required. They found properly that the county was not required to undertake any additional efforts above and beyond what was.
So you're saying to the appellate court here, the fact that someone went to the restaurant and asked for that could have not have happened, and you still would have satisfied even your due process obligations to provide
The Fourth
notice?
Department didn't exactly state whether that was not required at all. They said, assuming arguendo, that more was required. The due process analysis doesn't stop here. Assuming arguendo, something else was required, we find that the county fulfilled these obligations.
Do you think you could have done a little more? Because it seems to me, my recollection of what I read is they never, when that person went to the restaurant to ask for a person in charge, they didn't say this is about a tax foreclosure or this property is about to be foreclosed upon or anything like that. They just said, we want to talk to someone in charge. It's very important.
It's very important, it's very imperative.
Do you
They
think a
left
little
messages.
additional information might have satisfied due process even more?
Even more, I mean, obviously, there are always more things.
There's always
that-
more you can do.
There's always more that can be done.
Well,
but
you-
at what
why
point
not
is it
post?
reasonable?
Why not
post?
post
Why
on the
not
door?
bring the petition with you? A copy of the notice and petitions with you and leave it with the card?
Your Honor, in this instance, we only had perhaps 2 or 3 weeks prior to the redemption deadline. Plus, we had other properties in order to conduct additional outreach.
Yeah, but it
So in
strikes
this
me
one-
if the treasurer is actually going out of his way, unless he was going to the diner anyway, I don't think so, he's only there for 3 minutes, goes out of his way to go to the diner, why just leave your card? Why not leave the notice and the petition?
Because, Your Honor, the notices, what due process requires is analyzing the conduct of the owner to determine whether the municipality's noticing requirements were reasonable. What the treasurer knew at that point in time was 6 copies of these notices had already been received at the restaurant, signed for by an employee. It would be reasonable to assume that at an ongoing business, we have people who are in charge of payroll and staffing, handling cash transactions, making deposits at the bank. It would be reasonable to assume that they're opening the mail and responding to notices.
Understood. Supreme Court made findings of fact, and I think in those findings is that this taxpayer goes to the municipality and you tell her, no, there's no taxes owed here. And when you combine that with the fact that the municipality appears to be able to keep the extra money that's collected as a result of the sale, right? Does that present a problem for you?
There are several points in order to address your question. First off, the allegations that the taxpayer claims that she went to the municipality, went to different government offices and was given incorrect information.
But that's a
Those-
finding by the lower court. What
Right,
can
but
we do with
those are
that?
those are by the principles of equitable estoppel. So that can't be asserted as a defense against a government action, claiming, unless that there's proof of
What about its
active-
effect on the due process analysis?
The effect on the due process analysis is that after these interactions allegedly happened, the treasurer went to the restaurant and still made attempts at outreach to tell them that, to get somebody with an
But with
ownership
no
interest in
reference
charge.
to the foreclosure, to the lien proceeding. It's strictly about something important. At a time when she's going to the taxing authorities to confirm the existence of a debt, and they're telling her there isn't one.
Your Honor, there's no evidence that that information came from the treasurer's office. I believe that the plaintiff was claiming that she went to the town in order to ask, and was given incorrect, or that somebody from the town had called the county and that the incorrect information was relayed. I mean,
But that didn't happen only once, it happened a few times.
that's what she claimed. That's what she
But that
claimed.
was a
But they're
finding.
findings. So now, should we be concerned at all that the county or the town or the entity tells a person, no, you don't owe anything on multiple occasions, and then a short time later turns around and takes the property. Like, that's concerning.
Your Honor,
That could turn into a business model for a municipality.
It would not turn into a business model for a municipality, and also those are barred by the concept of equitable estoppel. That can't be asserted against a government action to claim without further proof that it was motivated by fraud or by some other improper
So you're saying it's even
motive.
harder to make that case against the government? That
It
to
is,
me would
according-
sound more concerning, not less
But
concerning.
according to the cases that are cited in the county's brief, that equitable estoppel can't be asserted as a defense to government action unless there's
Well, why
proof
not
of-
The
just take the
reality is
check?
that she's
Day
getting
after-
conflicting information. This is not the case where the government says over and over, without any conflicting information, no taxes are due.
But Your Honor,
So
also.
she's got someone visiting, right?
The timing of, in this case, on January 9th, 10th, and 11th, with the outreach that took place by the county treasurer, calling the restaurant, saying this is very important, somebody, an owner or
But that's
person
my
in charge.
point. I thought you were arguing that you're going back and forth over what government has said, but the reality is she's got conflicting information from government employees. So you can't really say that it's the same kind of reliance as in those cases where the government's representation through the employee is the same over and over.
Your Honor, in this case.
Which it would we not say then she has a burden to do something else and get this straight?
Your Honor, in this case, had Mrs. Hetelekides called the county, returned the treasurer's phone calls on January 9th or 10th, or come out to meet with him when he went to the restaurant on the 11th and said, great, I'll be there
At the
Friday morning.
time that she claims she went to the town, was it too late to redeem the property then?
According to the appellant's testimony, she claims that she went before. However, the testimony developed at trial shows that she did go to the town, that the town employees said that they had this one interaction with her, and then the records, the record below shows that those employees, that the town was actually open on the Martin Luther King holiday, which was after the redemption deadline. The redemption deadline was on the 12th of January. Martin Luther King Day fell on the 15th of January that particular year.
When did she come with an offer of $20,000? Was that the 14th?
She came in actually on the 16th because the county offices were closed for the Martin Luther King holiday on the 15th. She came in on the 16th and then said that she was able to, she would pay the taxes. However, she was advised that she wasn't able to, and then immediately.
Too late. The
It was too
redemption
late.
period
It was
had
too late.
closed.
And then interestingly, Your Honor, she retained counsel within a very short period of time. At that point in time, she was afforded relief under 1131 of the RPTL, where we could seek vacator of the default judgment for a reasonable excuse for the default, or even, as the Fourth Department has been holding, for sufficient reason and in the interest of substantial justice.
I know, but still, it's troubling, isn't it? She shows up the next day with a $25,000 check that will cure this. They say no, thank you, and then they make a $120,000 windfall.
Your Honor, to your point, there are remedies that are available to the taxpayer under the RPTL. In that instance, she could have gone into court and filed a proceeding in order to vacate that default judgment for sufficient reasons and in the interest of substantial justice. She could have brought up, hey, I tried to find out that these taxes were due. Hey, I
Okay,
had the money.
she had an attorney. What if somebody didn't? And they didn't know what their remedies were?
Sure, I mean, to your point, in this instance, that makes that even more substantial, the fact that she was represented by counsel at that time and didn't afford herself to that relief, that could have very well have, instead of trying to go before the Board of Supervisors and make this argument for relief that never had been granted by the county in the past.
Thank you, counsel.
Thank you, Your Honors.